My name is David Cormack. I'm the Chair of Prison Fellowship Queensland, which is part of Prison Fellowship Australia. We've provided 2 submissions to the inquiry, and to understand, I guess, our second submission, you really have to touch base on our first submission. Our first submission was in relation to a restorative program that we conduct in prisons, and principally it's been conducted in the Southern Queensland Correctional Centre since 2011, and that program involves taking crime survivors or victims of crime into a custodial setting, such as that centre out at Gatton, and over an 8-week program meeting with offenders and working through a range of topics. And the people involved are not the actual offender and the actual victim, but people of like offences. So, for instance, we've taken in people who have lost loved ones to murder. We've taken in people who have been the subject of violent sexual assaults, armed robberies, those sorts of things, and then they meet with people who are serving sentences for those sorts of offences. And then they work through a model of trying to get to know each other, and then working through the effects of the offence from the crime survivor's perspective. We call that the ripple effect, and how that's changed their lives. And then there's also a process where the offenders talk about how they have got to that point. And then there's an opportunity for some healing where there's an option for people to write down a letter as if they were writing to, for instance, their offender. So the victim writes a letter and sets out where they are at, and the inmate does the same thing. Appreciably, these letters can't be sent to the actual people, but it literally takes 2 weeks, and it's near the end of the course, for them to be able to undertake that task, because it is a monumental task for people to reflect about that from each perspective. And then they share those letters in the group, and all of this is undertaken in a group setting, and it's heavily reliant on dialogue and storytelling, basically. It's not a program where people work through a manual and watch PowerPoint slides and that sort of thing. It's heavily reliant on engaging with each other. And then at the end, there is a graduation and a celebration. And we have had, numerous members of the judiciary participate, members of parliament, as well as members of the community who come to the celebration service to see how this actually works. They have the opportunity to speak to the crime survivors, and they have the opportunity to speak to the inmates as well. And there's videos on YouTube and other resources that are included in the submission that are publicly available if you want to see how that all works. So our initial submission was about that, and then we noticed in the draft report that there was a recommendation that there would be a restorative aspect to the sentencing process, and how would that work. So where we've been engaged is, because there is no mechanism for that to happen under our current model, is we've been engaged with people generally right at the end of their sentence. So they may be looking to be released in the next 2 years. The course that we undertake is not for parole. It's not accredited for parole. So it has the benefit of, and the people, the way they are selected, are genuinely involved, because it's not just a course that people complete to be able to put on their material for the parole board. But it has the disadvantage that it's happening 10, 15 years after offences. And so when the draft paper suggested, well, how would this work if we actually included it in the sentencing process, sort of front end, we put in another submission about that. And I'll touch a bit about that today. And it's appreciably a novel area. I mean, other jurisdictions, the ACT, Victoria, have similar concepts and engage in that way. So we have sort of touched from there. But from our perspective, it would have to be included as part of the legislative framework. So you have a piece of legislation called the Penalties and Sentences Act that governs the principles that judicial officers would have to apply when sentencing an offender. We suggest that it should be incorporated in that legislation if it is to have any teeth, and so that the judicial officer would then be able to consider the relative principles that are set out in the Act as to what needs to happen. As to the mechanics of how all that would work, I guess, as I say, the devil's in the detail, because you would, in our opinion, you would need to be engaging people that have intimated they will be entering a plea of guilty. And that's, in our opinion, the only way it could appreciably work. It couldn't work in any setting where the offender was contesting the offence, because in our experience, the key to any restorative process is that there has to be some acknowledgement of fault. And so you would need to be engaging people who have indicated that. And as to the role of the crime survivor or the victim, it's a little bit tricky at that stage because many crime survivors at that stage are very raw. They're still very impacted by what's happened, and they may not be in a position to engage in the process. They may not psychologically be up to it. There are those that are in a position, and for that reason there would have to be a support base to provide a screening as to those people who would be able to realistically participate, and to provide support for them as they go through that process by way of counselling or other measures. There are a variety of groups. I guess the most notable group is a group called Blue Knot. They are working in the space of the historical sexual abuse. They're providing training for people who are involved in trauma-informed care. Groups like that, and there are others obviously, are engaged already with people who have been subject to horrendous criminal offences. So they would need some sort of support through that mechanism as well. But if you have an offender who is indicating a willingness to want to participate, and you don't have a crime survivor or victim, which is what we find often the case, is you would have to consider, in our opinion, the use of a surrogate victim. So not the actual person involved in the offence. Because if you are and it depends, the focus. If the focus is that you're looking to reduce recidivism and you're looking to engage with the offender, then you can still do that with a surrogate victim. So that person has to go through that process where they understand the effect of their crime and engage and develop empathy for what has happened, because that's the key marker from our reviews of reducing offending, is that you have to build empathy, and offenders don't have empathy. And that's one of the matters that I guess was a bit surprising for us, is that it took, until probably week 4 or 5 of the course for the offenders to start to process that what they had done actually was a huge deal for the victims. And a lot of offenders who may have committed armed robberies and they haven't shot anyone, or they've broken into someone's house and they've just taken stuff, they don't process the way we process and say, well, that actually really, really affected that person. That person can't leave their home anymore, or they've lost their relationships, their marriage has broken down, or they haven't been able to interact with their kids because they say, oh, I didn't hurt anyone, I didn't shoot anyone, they've got an insurance policy to cover what I took, and they don't really process, because the dysfunctionality of their lives up to that point in time has calloused and hardened those parts of their brain and their emotions to actually register empathy. And it's not until they're in an environment, so in the course that we engage in, where the person there is not there to judge them, they're there simply to engage in the process and dialogue with them, that they start to understand this person's life has been horrendously affected, and it's been affected by something that I've done to someone else, and that means that that person whose life would also have been affected. So in that respect, we think that a surrogate victim would be useful if the actual victim wouldn't participate and wasn't in a position to participate. If you're looking to actually engage the offender and reduce the risks of the offender reoffending. As to the agreement that they reach, which is part of the draft report, as to the victim and the offender can reach an agreement in relation to the sentence. Again, that's going to be a very sticky issue, because there will be, as invariably there are in situations where you get to know someone and speak to them with fairly intense subjects, there's going to be an imbalance in terms of, I guess you can call it power, but there's going to be an imbalance in the ability to actually find the correct sentence. So for that reason, we suggest that the agreement that the offender and the victim reach still has to be subject to review of an independent body. So, ordinarily you would have a prosecutor involved in these matters, and it should either go before a like type body to see that there is some parity in the options, because when matters go before courts, they like to keep, some sort of guide as to, well, if this sort of offence happened, these are the sort of sentence you can receive. So you would need to keep some sort of parity for sentences, but still to give the offender the benefit of having engaged in the process and a reduction in the sentence. They should, in our opinion, still be entitled to that because they are saving the resources, they're assisting the victim if the victim's actually participating, and they are hopefully going to cost society less in terms of reoffending, which is obviously an enormous cost. In terms of the balance, there's just an enormous array of support that needs to take place after that. Who engages in the facilitation between the victim and the offender? These people would need a mediator or a facilitator to help them navigate that process. You would need to obviously have qualified people to do that. Should those people be part of, the Attorney General or the another arm of the government, or should they be an independent body? That needs to be clearly thought out, because in our experience working in prisons, the one advantage we have is that because we're a not-for-profit organisation, we are accepted by both sides because we're not there as part of the system, we're not being paid, we're there because people accept that we genuinely want to be involved. And so there is a potential that if it just becomes another arm of government, that people will, and even if it's the wrong perception, and people have the wrong perception, that it's simply going to be part of a process and another bureaucratical step that's engaged in, and the person isn't really engaged in what I'm trying to do or listening to me. So there is the option we suggest of engaging not-for-profit organisations to do that, and the benefit of that, of course, is they tend to be able to deliver services in a more affordable way. They have, the use of volunteers for many aspects. They have the use of other networks that allow them to actually deliver services very efficiently. So that's one of our recommendations that needs to be considered, as well as the training of the people, and whether you sort of settle on a facilitator type model or a mediator type model. These are matters that require considerable thought. There's, I guess, a range of other matters, but I might take a breather and allow for questions before I get into the other substance.
Thank you, David. That was really comprehensive in terms of some of the work you're doing, your organisation, and thanks too for the submission from your organisation to the inquiry. Just want to ask, and also make a comment that we've had, and we can see from the information available, really low traction in terms of restorative processes. Why do you think that is? And in terms of also, what do you think the barriers are then to bringing those into play? Because certainly if there are barriers in the past and we have a low incidence of seeing those, then that's going to be something we need to address in going forward.
Well, the biggest barrier is that people perceive anything other than locking up people for long periods of time as being soft on crime. And it is very unfortunate that message is the default message, whether it's on any media you look at, whichever politician, whichever side of politics, it is always, when these issues come up, we'll be tough on crime, we'll increase sentences, we'll increase minimum parole periods, we'll introduce mandatory sentencing, we'll do this, we'll do that. And as soon as you say, well, maybe there's an alternative where you don't do that, they say that's soft on crime. My response to that, and we've got videos where our crime survivors have spoken to us, and we've recorded those, is it's not soft on crime. When we go into the prisons and engage with the inmates, they are literally petrified. This is the first time they have had to have any sort of serious dialogue with a victim, and they are mortified. These are people who are accustomed to doing violent offences or a range of other activities, and they are just absolutely mortified because they have to deal with issues. And it's not just a victim impact statement where, it gets read out and the victim speaks for 10 minutes or 15 minutes and that's that, and they tune out. And they have to be engaged for 8 weeks. They have to see this person, for lengthy periods of time. And until people understand that that is a tough process and it is by no means soft on crime, people will just go to the default option, which you can sell in 15 seconds. We'll increase this sentence, we'll make that sentence mandatory. But to be able to discuss this issue, you've got to engage people's attention for, 30 minutes. And that's almost impossible these days. So that's your single biggest barrier, is persuading people that if you engage in this process, you're going to reduce your risks. But people have to be willing to listen. And I would invite, as part of that process, that they engage with the victims and that have participated in our course over the years and say, well, what was your perception of the inmates? And did you see the inmates taking on board what you were saying and actually making a change in their lives? So that's, the tough on crime barrier is going to be your single biggest barrier from my perspective.
Yep. Thank you, David. I'm just wondering also, have you had, or do you know of, or you visited maybe, some of the New Zealand programs or Canadian programs at all? Or you're aware of those?
Well, yes, I am. Our model, which is the Sycamore Tree Project, is based on an international model, and our training was done by New Zealand. So okay. New Zealand, who have been delivering this program for decades. So our facilitator, a fellow by the name of Martin Howard, went to New Zealand, was accredited in the training, and is now since become accredited to deliver the training here. But yes, the New Zealand model is largely what we've modelled ourselves.
Yeah, because I'm aware that model allows for some regional differences, rural and remote differences as opposed to urban or high needs, and also depends on in terms of different types of crimes as well. So,
yes, and so for instance, one of the barriers we've identified is working with Indigenous inmates. So for instance, in Lotus Glen, outside of Mareeba, we would need to change our model and have stories from people in a video content because of the difficulties that Indigenous inmates have in dealing with things face to face. So there are matters that would have to change depending on the matters involved.
Thank you. Commissioner Wood.
David, are there some crimes that just aren't appropriate for this method of justice? For instance, sexual crimes, rape, things like that? It's a question, not a pejorative statement. I'm really just interested to see what your response is.
We have found that, because historically any sort of sexual offence was off limits when we first got approval from corrective services. But we've found that it's not a barrier.
Right.
It really does come down to, I guess, the screening of the people willing to participate.
Okay.
So we don't randomly engage people to participate in the course. We're a faith-based organisation. We have volunteer chaplains, and the chaplains submit names. Those names go to management. The management check that there's no reason why those people can't participate. They haven't breached various conduct or other matters, and then those people engage in the course. So key to any participation is making sure that the offender genuinely wants to participate and is not simply doing it for some other reasons, and that will be a significant hurdle, I guess, in any restorative justice at the sentencing end, because it'd be quite difficult to screen that. But you really do need to engage with the offender just to see how genuine they are in wanting to participate in that process.
Thank you for that. I have another question. How scalable is the process? This will be resource and time intensive. And look, in a system where the legislation supports formally the process and potentially allows for some discount of sentencing if you go through a process, there's some cost to be saved. How scalable is it? Can it be applied to a wide range of participants, or will this be a niche type activity?
It will be very difficult to mainstream it, simply because it is resource intensive. What we've recommended in our submission is that a pilot program is undertaken in places like, obviously, Brisbane, Southport, and other hotspots like Townsville, to see what the wrinkles are. We undertook a pilot study to commence our course, and as part of that pilot process, we had one of the clinical psychologists from the centre, observing how it worked for the 8 weeks. So you would need to develop protocols for your pilot study before I think you took further steps of how to roll it out.
Yep. Just wondering, David, in terms of the screening, and you've mentioned screening a number of times, and the importance of screening participants to ensure they're suitable. What about in terms of that? Currently we have delays and we have a lot of time and people are waiting to be sentencing. So is there instances where screening could be fast-tracked, or where screening is not as maybe not as intensively needed as other times?
And again, I think this is where the use of not-for-profit groups, it might be a bit of a bandwagon, because I've seen the work they do, but it allows you to engage in that process. There's plenty of groups that could undertake that screening process for you at an affordable cost to see whether the person, including both the offender and the victim, were in a place to engage in it. And you're right, nothing happens quickly when it comes to sentencing.
Yeah.
So you would have the benefit of that. And then obviously there's a cost.
That's
Who's
right.
going to pay for it all?
That's right. Right. Commissioner Wood, do you have any further questions?
I do. David, it's been mentioned in some of our interactions with the Judiciary, Department of Justice and others that there is some scope for restorative justice within the current legislative framework. Do you have any comments about that?
Oh, I think, what you have is, and I guess this was picked up in the first draft report about, they're really just hodgepodge, and they're not really designed for to be engaged with a criminal offence. And there's no support mechanism to enable it. I mean, I know there are mediators that can engage in restorative justice, but there's no real pathway for a criminal offence to go through that in any sort of structured way. It's just, we've got a couple of sections in this act, and we've got another couple of sections in another act, and maybe you can find a pathway through all of those. That never works, and it hasn't worked because it hasn't been used. And people don't know about it and don't know what the mechanism is and how you put it all together. So none of those, I think there's 4 other pieces of legislation that was in the draft report, and it hasn't worked.
Thank you.
I think you've been clear. Another question: if the legislative framework did exist, and if the mechanism was there, what's to stop an offender from gaming a system like this? What would the mechanisms need to be to stop gaming for a reduced sentence? If there's an incentive for a lower sentence or a shorter sentence, I assume there'd be some attraction for having a go at it, whether you were serious or not in your views.
I guess that's part of, and they're imperfect, but that's part of the screening process, and it's also part of, I think, the role of the independent body for whatever agreement is reached. How engaged that body becomes is another issue, and it's up, hopefully, if you have the right facilitators and mediators, and I think you would need to have them involved, they would be in tune with whether the person was engaged or just trying to tick a box as part of the process. They might game the mediator and facilitator, but you need the appropriate checks and balances in place for that.
Mm-hmm.
Because ultimately, what you're trying to do is reduce the person reoffending. If the person isn't interested in the process but is only interested in a reduced sentence, then it's not going to be beneficial.
I guess that leads then to a follow-up question. What's the evidentiary base like internationally to support a restorative justice process? As you noted, one of our draft recommendations supports a restorative justice process, and our visits to the Murray Court, you see echoes of restorative justice to some degree. Looks really encouraging and really positive. Is there an international evidentiary base that's compelling?
There's a variety of studies, and they all have different outcomes. There's no sort of accepted evidentiary base that says, you get X%. What you do get is generally a significant reduction in the reoffending. Now that may range in percentage terms, but the other outcome, and I guess one of the main outcomes that have driven our participation in the work, is that it changes the life of the victim that participates. So we sort of see our role fairly uniquely in that we're working with inmates, but we are very conscious of the impact of the offence on the victim, and we see the benefit to the victim just as much as the benefit to the offender. And so for that reason we think there's a cost benefit to society, not just in terms of that the person will hopefully not offend again, but that there will be less cost to society for the broken lives of the victims.
Thanks. I'll open up to the floor. I'm going to swing back across now to the floor and ask if there's any comments from people on the floor. Yes, please remember please to say your name and where you're from.
Wayne Sanderson. I'm a clinical psychologist, mostly retired, and I'm a Uniting Church minister, entirely retired, And I've been working for 7 years with the Balanced Justice Campaign, which is addressing totally the youth justice system of Queensland with an advocacy and reform process. But I'm very curious, everybody gets older, of course. I'm very curious to hear from you. Is your work also done with people on remand as well as people who've been sentenced?
No, they won't. Or corrective services won't let us anywhere near people on remand.
Because I had in mind some people spend a long time on remand.
They have to have been sentenced.
Thank you.
Any further comments? Yes.
Can I make a comment? But
Please,
if any.
please say who you are.
My name's Peter Russo. I'm the state member for Toohey.
Thank you, Peter.
And a member of the Labor Party. I just want to pick up on this tough on crime debate that goes on. I just invite people to have a look what happened in Parliament this week. The LNP introduced 2 bills asking for increased penalties in relation to firearm offences. Yep. They also asked for increased penalties for trespassers in relation to the protesters that are going on to private farms. And they're actually running a campaign. This gets personal, but we're supposed to be tougher than this, they tell me. But they're actually running a campaign against me because of my former life. I was a defence lawyer, and I think anyone who knows me knows my stance in relation to penalties. And so we've got a real issue in this state when you have one particular part, and I'm going to have to get political, and I apologise for that in advance for the non-believers, but when you have one particular political party that's going to push this law and order agenda, the public really don't, without being disrespectful to the great work that happens here, but selling that message out in the public is really difficult. I'll give you another example. In the Courier Mail this week, Sarah Fogel she wrote an article about basically get out of jail free, referring to the Queensland Sentencing Authority's inquiry into basically prison time, etc., for paraphrasing. And that was picked up on, and then then the next rhetoric that was coming on WeChat and the social media was never vote Labor, because if you vote Labor, this is the type of thing you will have. Now, I know we're not without sin. All I can tell you is that I argue very strongly in caucus, and
I'm going to interrupt you,
that's it.
Peter, and refer that we're taking comments on the presentations, and I ask people
Well, it's the
people to comment on what the presentations are and not to enter into other spaces. Thank you.
Yeah, well, what I'm trying to say is if you're going to sell this idea of doing the restorative justice, there are a lot of other... the rhetoric that will be run, that this is another example of people being soft on crime.
Thank you, Peter, for your comment. We'll take any further comments from members. I've got one over here and then you. So please remember who you are and where you're from, and then
David
talk
Lunnis
to
from
the
Anglican
issue.
Prison Ministry. David, thank you very much for your presentation today and for your submissions. Thank you also for the work that you're doing out at Gatton and the work you do there with the prisoners. I work with a lot of high-profile prisoners, and my concern is that when victims are informed that they're about to be released, the victims often call for public support that they may return to prison despite having completed their term of offence. It continues to show that their grief has not been dealt with, and one of the issues I have with that is that in our court system, we have a court system which tries to remove the decision about the sentence that the perpetrator needs to have, and taking it out of the emotion of the situation for the victim. I understand that. But the consultation process that we're talking about in restorative justice, how can we extend that, do you think, so that the consultation starts earlier in the process? And does it always have to be with surrogate people? So that we avoid, so that the community can be more involved in the process of discussing sentencing and overcoming and dealing with the grief as it occurs. Do you understand what I'm saying? I'm trying to say that.
Yeah, it's
Thank
all
you.
very hard.
It's very hard. I think it works with the restorative justice issues for me.
It's, I guess it'll take an enormous shift in public perception to move away from immediately wanting to seek retribution or always wanting to penalise someone even though they have completed their offence, especially if they're a dangerous prisoner, sexual offence, and they're coming back into the community. I mean, we've worked with notorious prisoners in those circumstances to provide some sort of refuge for them, and also to provide an alternative so that the police don't have to be in constant supervision and use the police powers to monitor these people. But to change that default mechanism where people simply want retribution is going to take an enormous process, because that is so easily the natural inclination, and it's what gets media attention. This person is grieving, this is a horrible person, here's what they've done, why should they be allowed back into my community, my schools, 2 kilometres down the road? Why do I want this horrible person around? When the reality is that those people are at more risk of an offence against them from someone they already have in their community and who is known to them. We have dealt with sexual offenders who are so well known that the prospect of any offence, new offence taking place is zero, because they're severely monitored. I mean, not severely, but constantly monitored. And you have people in the same community living with family members who are more likely to commit an offence of that nature in the same community. And it fails to understand the risk analysis of what's taking place. But for people to engage in that process and understand that this person, despite all the horrible things they have done, is unlikely to be a risk to them, doesn't sell. It's not a news item.
We're going to wind it up.
I think we've got one final question.
One final comment, and if you can be very brief, please, because we're now
very much.
over time.
Paul Bryden, Anglican chaplain at Woodford. Thank you for your presentation. I think an aspect of it which is very important is that it's community-based. And I'm involved in Kairos organisations, also community-based. And I know that the men really appreciate seeing people from outside the system taking an interest in them. And I'd certainly encourage the authorities to look for opportunities to invite local community members, maybe the local librarian to come and help the library, anything like that, to help the men feel that they're in contact with the community. Thank you.
Thank you. We're going to close that there. I'm going to finish the session now. We're going to then enter into morning tea for a short break. We are due back at 11 o'clock, where we'll have the next presentation then. Okay, so please enjoy and have a short break.
Thank you, David. Well done. Thank you.